This is Liberty Law Talk, part of Liberty Fund's online library of law and liberty. Your host is Liberty Fund Fellow Richard Reinsch. Our web address is libertylawsite.org, where you can subscribe, comment, find other episodes and links related to today's conversation. Our email address is lal@libertyfund.org. Today we are discussing with Louis Fisher his latest book, Congress, Protecting Individual Rights. Louis Fisher is scholar in residence at the Constitution Project, located in Washington, D.C. I won't even attempt to recite the list of books and articles he's written. However, some that I should mention: Constitutional Conflicts Between Congress and the President, now in its 6th edition, Presidential War Power in its 3rd edition, and Military Tribunals and Presidential Power, winner of the Richard E. Neustadt Award. Louis, glad to have you on the program.
Very nice to be with you.
Your book, Congress Protecting Individual Rights, I thought perhaps I might read from the opening of the book on page 1, because I thought two paragraphs that nicely shape the book and the arguments you're going to be making, and just get you to comment on it. You say, "The framers created a constitutional system that depends heavily on checks and balances to avoid the abuse of political power concentrated in one branch. The purpose is to protect individual rights and the aspiration for self-government. That principle largely governed the federal government for the first century and a half. In the years following World War II, the American political and legal culture changed fundamentally to favor a strong president empowered to initiate national security and domestic policy on his own. Over that same period, the Supreme Court emerged with the reputation of providing the final word on the meaning of the Constitution. Both developments would have astonished the framers. Without a strong and independent Congress, we could not speak of democracy in America. Our political system would operate with 2 elected officers in the executive branch and none in the judiciary, a form of government best described as elitist." Louis, why is Congress seen by many, to quote the title of a recent book, as the broken branch?
You may notice that Norm Ornstein on the back of the book has a nice promotional statement about my book. And
Yes.
in doing my book and reading all the way we evaluate the 3 branches, I was struck by the fact that people don't like Congress because when they watch it on floor debate or in committee, they see debate, they see deliberation, they see amendments, and that's what you would expect of a legislative body. But it's funny, that's every legislative body does that, and the same certainly occurs in the other 2 branches, but we don't see it. We don't see the kind of debate that goes on inside the Situation Room or inside the conference room of the Supreme Court. So somehow Congress gets a bad mark for doing what legislative bodies do. So it's just built in. Congress rarely will ever be a popular branch. And I say also in my book that I think it's true that we 2 different ways we measure the 3 branches. For president, we idealize the president no matter how many catastrophes we've had in the White House. We idealize the Supreme Court no matter how many bad decisions has come down. And we certainly don't idealize Congress, very realistic about Congress. So that's the way it is. And Congress doesn't help itself. I thought Congress, I became a congressional staffer in 1970, and I thought the institution protected itself in a bipartisan way for about 25 years. And then I noticed in 1995, with Gingrich coming in, a very change on the independence and strength of committees and subcommittees, and I think Congress has been on a downhill from 1995 to the present time.
More broadly in the book, you say that within our 3-branch system of government, it's Congress, not the courts, not the executive branch, that has the best record protecting individual rights. Yet it's the court that most Americans would point to in this regard. So maybe flesh that out for us. Why is Congress on the basis of the historical record the better protector of individual rights?
I don't even in my book have a great answer for that. I just look at the record, and I think the protections you see for blacks and women and children and so forth it certainly did not come from the Supreme Court for at least 150 years, and didn't come that much from the president. It came from Congress through the regular political process. So I just, 2 quick points. Congress, after the Civil War, passed legislation to provide blacks equal access to public accommodations, restaurants and theaters and railroads and so forth. And that was struck down by the Supreme Court in 1883. So we didn't get a public accommodations provision until 1964. I mean, Congress was so far ahead of the Supreme Court. So that's about blacks. And then I say in my book about women after the Civil War, they tried to practice law, and they would go to judges, both state judges and federal judges, and get nowhere. They would be told that there's, as the Supreme Court said in a decision, that there's a divine ordinance that tells women to be here to take care of husbands and children, not to be involved in professional matters. And in the 1870s, a woman went to Congress. The Supreme Court had a rule that women cannot practice there. And the woman had a draft bill, said women can practice there. And you have to ask yourself, Congress at the time, all men, are they going to be at all sympathetic? And her bill passed within 1 year. So it's extremely impressive how Congress had a much more sophisticated judgment on the rights of individuals than the Supreme Court had.
Yeah. Interesting in this regard, too, you quote from Ronald Dworkin's famous book, Law's Empire, where he argued for a model that would entrust to the Supreme Court the protection of individual rights. And he said, quote, "The United States is a more just society than it would have been had its constitutional rights been left to the conscience of majoritarian institutions," end quote. And in a footnote, he acknowledged that he offered, you say, no argument for his flat claim.
Right.
And he says, he did not take into account that the court's record had been spotty. In this book, in the chapters, you go through judicial decisions regarding blacks, women, children, religious minorities, and Native Americans led, you say, to a less just society. Repeatedly, the corrective force came from legislative bodies and public participation.
Yes.
Yeah.
Still there? Okay.
Okay. So in thinking about, in particular, this sort of dynamic that's working, though, so what changed, obviously, is the Warren Court. I mean, that's the big intervention historically, where we now see most Americans look to that record to the extent they think about it. They think of the court protecting individual rights, and it's this sort of major intervention from the Warren Court.
That's true, and I spend time, and many other people have done the same, to point that the Brown v. Board in 1954 is looked to as a great advance, but the court undercut itself in Brown versus Board the next year by using all the words we know about, all deliberate speed and things like that. So there was a very political decision. They got a unanimous vote in 1954 with the understanding that the states can take quite a long time in doing anything to comply with what the court said is the constitutional value.
So Brown v. Board, nothing really happens, as you point out in the book. I mean, I forget, I think I've read something like 80% of school districts that were segregated at the time of Brown versus Board were still segregated 10 years later. I don't know if that's, I mean, it's something like that. It's an absurd number. Progress. So Brown v. Board, we point to it, but it doesn't really do much in the sense of enforcement. That comes with Civil Rights Act of 1964.
Yeah, and then the Voting Rights Act the next year in 65.
Yeah, so in thinking about that more often or more in depth, you just mentioned it, the Civil Rights Act of 1875, which remarkably, I mean, it's interesting. I guess I hadn't thought that much about the wording of that statute, but really did the work of the Civil Rights Act of 1964, but was struck down by the court or not enforced by the court.
Yeah, it actually struck down. I mean, the court said that equal accommodations somehow violated states' rights and private rights. And when that bill came through, equal accommodations, the person leading it in the House made clear that this has nothing to do with your private associations and your friends. That's totally up to you. But anything of a public facility, there should be equal accommodation. And I also think on the rights of women practicing law, there was a senator from California, Aaron Sargent, and in defending the bill to have women practice law before the Supreme Court, he said we have no more right to interfere with the dreams and aspirations of our brothers, by that he meant black men, than we do to interfere with the dreams and aspirations of our sisters. I mean, that is a really extraordinary understanding that people here as individuals need a right to pursue their dreams. And you couldn't get that from the court at all. You got that from Congress.
Thinking about on this question, that something that I read earlier at the beginning of the interview, Congress accepts the court as providing the last word on interpretation of the Constitution. Maybe talk about that as sort of, because I'm thinking about sort of linchpins or background formation to the current relationship of separation of powers. That seems to me a crucial period. You talk about in the book, after Dred Scott, the Congress does not give up on trying to regulate slavery in the territories, meaning they didn't accept that opinion as the final word on that question. Correct.
And one thing that Dred Scott said, you can't rule out slavery in the territories. And that was one of the first things that after Lincoln came in, Congress passed legislation prohibiting slavery in the territories. So no one took Dred Scott as the last word. Eventually overturned by amendments, but before that overturned by statutes.
Yeah. Thinking also about just sort of this loss of self-government, which is also a part of informing your book. What do you attribute that to in terms of Congress's? I mean, has Congress done this to itself in relation to the Supreme Court, in relation to the executive branch? Has it willingly sort of let its privileges go? What do you think?
I think a lot of it's self-inflicted damage by Congress on itself. I give some floor statements there by people very experienced in Congress who have chaired the judiciary committees in the House and the Senate. And they will, when the Supreme Court case comes down, they will raise some questions about it. But then they'll say, complete reverse, that the Supreme Court has decided and it's final. And there's nothing in history to support that. So I don't know why members, for all their experience, would ever say such a thing. And we know that even recently with equal pay for women, the Lilly Ledbetter case, she went to Supreme Court and lost. She'd been discriminated against for decades. And the court said, you didn't file in time. Well, she didn't file in time because she didn't know. And came back, and Justice Ginsburg, as she often does, she dissented and said that the ball is now in the court of Congress. And Congress passed legislation saying that when you're discriminated against, that discrimination carries forward from every paycheck on. And that meant that the women could file at any time. So women, again, that's 2009, got protection from Congress, not from the Supreme Court.
Yeah. The question of Congress, sort of coming back to this foregoing of its claims to self-government, I'm just thinking about race. I mean, there's an argument there, too, that Congress couldn't get its act together with regard to race for a long time, up until the Civil Rights Act of 1964, that somehow this sort of emptied it of its having the prestige and ability to deal with these claims and questions.
Well, it's a good point you make, and a fair one, and Congress didn't do its proper job, but of course we can say that about the Supreme Court. It was the one that came up with a separate but equal doctrine, Plessy versus Ferguson, 1896, and the court took a long time to get its act together also. And I think here we have to give credit not just to the institutions, look at the Supreme Court or Congress. We have to give credit to individuals in the United States who refuse to accept separate but equal, and they, with litigation, push back decade after decade, and that's why I think that's how we got progress, and we also got progress because of World War II. After World War II, the Russians could easily say that communism is better because look at the United States with all its racial discrimination. So we had some international pressures coming at us. So I think I hope what comes out of my book is that a lot of the progress we've made comes from the private sector refusing to accept what the branches have done, and I think that comes out well in that 1940 case, an 8-1 decision upholding compulsory flag salutes in public schools, and Children of Jehovah's Witnesses refused to do that. They shouldn't bow down to a graven image. 8-1, you would think that's final, but the public reaction was so hostile to the court that it helped 3 justices who were part of the 8 realize they made a mistake, and in 1942 they admitted that the 1940 case was wrongly decided, so now it's 5-4, not 8-1, and 2 justices come off and 2 justices come on. In 1943, the Supreme Court strikes down its own decision, and I think that outside participation, that's self-government from the outside, people making independent judgments. And as you know, on slavery, none of the 3 branches acted appropriately, and all the pressure to get rid of slavery came from the private sector, from private citizens and religious groups, religious organizations. So that's part of self-government. We all have to take responsibility to speak up and combine with other people. Yeah. And not just sit around for the other 3 branches to do something.
We think in the powers of Congress, and just thinking about your book, Congress protecting individual rights. Congress now also seems to do, and some have argued, thinking of a recent book by James Buckley, arguing that Congress defers or sees itself as a manager of the regulatory state or the administrative state, and yet also sees itself as a manager of the states via something John DiIulio recently argued, government by grant to states, or government by trying to administer local concerns, local projects, but not actually engaging in sort of national debates or national projects and issues and concerns, but seeing itself, finding its power in the matrix of the administrative state or through these grants and largesse, things like that. And so this sort of empties the Congress of having the capacity for sort of this self-government idea and practice. Do you see that in your work, your legislation? Where do you come out on that?
I think that's a fair point. I think part of making Congress strong is to make sure that the state governments are strong and that they can perform self-government at that level. And I think it's foolish for Congress to think it can handle both national and state matters. So there has to be respect, and if states fall short, as Congress falls short, and the Supreme Court falls short, then people have to wake up and fix it by themselves. So I also think, as we've seen in recent years, that a lot of bills come on the floor for debate. They've never even been to committee. No public discussion. I think from 1995 on, the contract with America, part of its plank was to cut congressional committee staff by 1/3, and it's definitely gone down, and salaries have not gone up. And people I knew in the first couple of decades when I worked with Congress, they were careerists, and they were terrific. They were there for the long haul. And I think that has been undercut. A lot of people are less inclined to stay with Congress. They'll go somewhere else. So Congress, as even I say in my book in the last chapter, when Congress in the last couple of years wants to cut the budget, the first thing they cut is themselves. They cut their own capacity to perform as an independent branch. So Congress doesn't have, and certainly CRS, Congressional Research Service, and Library of Congress, it has lost most of its top staff, the top 2 levels. So Congress is deliberately hurting itself.
So how would it even engage? In one level, how would it even engage in sort of a debate with the massive layers of power in the executive branch?
Exactly.
Yeah.
And Congress in 1946 and 1945 and 1970 passed Legislative Reorganization Act recognizing that they were falling behind the executive branch, so they beefed up staff, and they've cut back. So no, they're hurting their own capacity to engage in self-government.
Yeah. You quote, this interesting book that came out in 2010, The Executive Unbound, by Eric Posner and Adrian Vermeule, arguing, this is interesting, I just wanted to talk with you about it. So you talk, so they're arguing essentially there is no rule of law that should effectively constrain the executive in the performance of its duties, except for the rule of politics and the role of public opinion. And you talk about sort of this again, the evidentiary record supporting the belief that it's best to let the primary energy in government be in the executive branch. Talk about your reaction to that book, what you made of it.
Well, I'll talk about that book, and a lot of political scientists, those are two law professors, a lot of political scientists have put the stress on the word you just used on energy and initiative as though you want presidents to do that. And a lot of presidents have taken energy and initiative to do things that were catastrophes, such as Lyndon Johnson escalating the war in Vietnam. So, no, these two law professors, an extreme form of that idealistic picture of the president I mentioned, and they would have no constitutional legal constraints on the president, just leave it up to his judgment and public reaction, and absolutely do away with any kind of legal structure. So that's, and they don't in their book give any attention to how many calamities presidents have done, not just Lyndon Johnson with Vietnam, but George W. Bush saying there's 6 reasons for Saddam Hussein to have weapons of mass destruction, and all 6 reasons were empty. No, we've had so many mistakes, and even with Obama going into Libya in 2011 to get rid of Gaddafi, and then having no idea, as Obama admitted about a year ago, he did step 1 without knowing what step 2 is. So we have a failed state in Libya and a breeding ground for terrorism. So, yeah, this idealism, none of the branches should be idealized, and we do it regularly. And I think they came from World War II on. I don't think you saw that before World War II, that putting on a pedestal the Supreme Court and the president, but we do it regularly now.
The exception of, you point to in your last chapter, Congress sort of, and this has obviously been a longstanding debate over the declare war clause, but Congress largely not having any desire to engage with the executive branch over the beginning of hostilities. I suppose with the Iraq War, with the Afghanistan War, we had the use of armed forces legislation, or grant. But largely Congress, as you point to, not seeming to want to wade in there and provide any sort of direction or guidance. Or even when it does disagree, it holds the ultimate power over funding, but seems reluctant to use that also.
Well, another, I think, destruction to the U.S. Constitution has come after World War II by creation of the United Nations, and Congress did pass legislation, and Truman signed it, saying that you cannot use the UN as a substitute for us. Anytime you use U.S. troops in a UN action, you must come to us first and get approval. And Truman signed that, and he had publicly said the same thing, that he will always come to Congress first. And then 5 years later with Korea, he did not do that, and Congress didn't protect itself. I think Truman violated not just the UN Participation Act, but the UN Participation Act reflected, quote, constitutional values, our own values. So Clinton regularly used military force, never came to Congress for one time, either went to the UN Security Council. If he couldn't get that, he'd go to NATO for authority. So I think those are fundamental violations of our Constitution, and Congress doesn't do anything about it.
The question is it something too? I mean, just the overall power of national security, or the overall apparatus of the national security state, which has only increased, particularly after 9/11, seems to make Congress irrelevant, or it seems to just fundamentally reshape. Yeah.
Yeah, it undercuts Congress. And I think national security is a powerful word. I think one of the great sentences from Justice Robert Jackson was in 1950, where he said, national security is like liberty in that many of the crimes committed in its name. So just to say national security shouldn't give you a green light to do whatever you want, but we're going in that direction. Yeah. And I do think, in addition to World War II, I think the availability of atomic weapons and nuclear weapons has made people defer much more to the executive branch, with the prospect of war coming. And I guess the most frightening thing we went through in the Kennedy years, where there was a human standoff between Russia and the United States. So I think all of that has terrorized people enough to concentrate power in the executive branch, and doesn't mean that presidents have any capacity to make good judgments.
Yeah. Well, in regards to Congress, contesting with the executive branch over war powers and over the use of war, though, how do you see? Have you thought about ways in which, or reform areas, or things it could advance against it?
Well, I think, the current situation with ISIS, I think Congress has an obligation to pass legislation. And for some reason, the House and the Senate and Republicans and Democrats can't get agreement, but it's necessary. Otherwise, you have another precedent of the president being able to, even the Obama administration has said this war will go on for possibly another decade. So to have a war continue of this breadth without any authority from Congress is, again, Congress hurting itself. It should pass legislation.
Yeah. Well, I suppose the authorization for the use of military force is I guess the cover at this point. But most would argue it doesn't exactly fit anymore. But is Congress actually, is there some sort of is that public opinion, as Posner and Vermeer would say, public opinion is largely on the side of continuing this sort of low-level war we're fighting? And
well, I don't know if that's true or not. I think the public would value elected members of Congress authorizing something, not just of this danger, but of the cost. It's another way of giving away the power of the purse to let presidents continue war that's not authorized. And as far as the authorization for use of military force after 9/11, that can hardly be grounds for what people call a forever war. If Congress authorizes something, there's nothing wrong with authorizing something for a 2 or 3 year period so that it can get fresh information and reauthorize with more up-to-date information than it had. Nothing wrong with that.
Yeah. Yeah. So talk about maybe here, I'm thinking about your last chapter, and you kind of go through some ideas of, Congress getting or Congress recovering its powers, or, recovering, or at least putting itself on a more even plane with the other branches. Kind of maybe go through some of those and just sort of list what we were talking about.
I think you might be amused that all that information in the last chapter, the chapter had been called Conclusions, and a lot of my friends legitimately said, you can't talk about that because you didn't talk about it earlier. So I realized I want to talk about this. I won't call it Conclusions. I'll call it Strengthening U.S. Democracy.
Yeah.
But, part of it is to have Congress staffed up so it can be capable, as I mentioned in that last chapter. Without adequate strength, and particularly committees and subcommittees, you end up leaning way too much on what the executive branch says or what private parties say. They're in there too. So Congress has to do that, and Congress has to strengthen what.
Let me think. I just want to think right there. Is it the case, though, that the sheer number of demands that are pressed by, say, a postmodern democracy on government, and a government's willingness to try and accommodate all of this, to just have a large government, does this somehow make Congress irrelevant. So you can actually find it. You can actually find your place more in the bureaucracy than you can in a congressional system that can't really accommodate all these demands.
Well, I think what you say is fair, but if it's too much for Congress, I think it would be too much for the executive branch. They're overloaded as well.
So is a problem just the size of the federal government? Is there no longer, if we no longer recognize any sort of limits to its powers or humility about what it actually could do?
Then I think Congress is more complicated world than a century ago, but then Congress has to make priorities, say that these things are important, the other things we'd like to do are less important. And I was impressed. Congress passed legislation on sex trafficking, of having these people use 9, 10-year-old boys and girls, and the House passed it, and I read the debate. It never got in the New York Times or the Washington Post, and it was really bipartisan, very well-informed debate as to what has to be done. And the Senate didn't do anything one year, and then they finally got it through the next. But it was a very, very fine example of Congress being able to tackle complicated subject and come up with constructive proposals and get it enacted. But no public attention to it.
What do you think, just thinking of the discussion on lessening the committee staff, it seems to me part of this is, Chris DeMuth has argued the need for a hierarchy within the committee system and the ability of committees to actually control what's happening, whereas now that doesn't seem to be, or to control and shape the flow of legislation. And to have key members on those committees who are there, year in and year out, so to speak, and that was sort of attenuated by 1970 reforms. And then as you mentioned, you talk about Gingrich era reforms also. But is that something that's missing?
I think it is missing, and I think it's tied to something else I talked about in the last chapter, campaign finance. And I do talk about this, I think, really insane idea that corporations are persons. Chief Justice Marshall in the Dartmouth case talked about that they're different. I mean, you can create a corporation by statute and give it eternal life. That's not what human beings are like. So there's a difference. Everyone understood that.
But there's the legal fiction of the corporate person.
It's a total fiction. I mean, it's something they thought the court decided that in 1886, and it didn't decide it. It put it up in the so-called summary, and the summary misstated what was in the decision. And once you make that confusion, it'll be there forever. People will always say something that was an error.
But I think the larger question on campaign finance expenditures, many would argue the idea of corporate personhood stretches back even to the founding era. And Madison making arguments over the personhood of corporations and receiving certain legal rights and entitlements resulting therefrom. Much of the law is constructed fictions. But on the question of campaign finance expenditures, so is the problem though? I guess the basic question though is the problem at campaign finance itself, or the fact that everyone wants to influence the government because it does so much?
Okay, that's a fair point. And I also think the problem with campaign finance is that when I talk to members of Congress, they seem to spend 25% or more of their time raising money, not just for themselves, but for the party. And if they don't raise the quotas assigned to them for the party, they can get kicked off a committee and they'll never be chair of a subcommittee, even no matter how long they're in Congress. So it's not only taking up their time, it affects how Congress runs itself. And it's too money-driven, and it undercuts the capacity of Congress to do what it should do.
So, I guess the question is, how do you stop water from going downhill? If the federal government is, as it was at one point, basically handing out bags of cash, and in the aftermath of the financial crisis, people want to influence that.
Of course. No, that's completely reasonable, and I think that what I say in the book is that Congress should hold hearings. As soon as Citizens United came down, I wrote an article saying Congress should hold hearings and see what this financial system does to self-government, and to democracy, and put its analysis together. And if the analysis requires a statute reducing corporate expenditures and elections, pass it. Then it would go to the Supreme Court, and the Supreme Court would have a choice to say that's exactly contrary to Citizens United, and that bill is unconstitutional. Or it could say, you are putting before us information we never had when we decided these cases in the past, and we have looked at your analysis, and we defer to your judgment. And that has happened many times in history, and I think it would be good for us to have it happen again.
What do you think about, just on this question itself, the incentives? I mean, Publius famously in the Federalist Papers talks about the incentives of the branch, the incentives of the institution, carrying members, forward in their duties, giving them reasons to push the arguments. What explains just this question right here? You're discussing, say, presenting an argument to the Supreme Court. So you're on, say, this question of campaign finance. And we're not going to recognize your decision. We're going to challenge your decision. Yet, as you and I have been discussing, they really don't want to do that. What explains sort of the disincentive of members of Congress to actually push forward the prerogatives of their branch, or not the prerogatives, but the institutional power of their branch?
Well, we've talked about a little about the reasons, and part of it is deification of the Supreme Court. It has the final word, judicial finality. It's a very unhealthy attitude, but many members buy into that. That's a mistake. I don't know enough about this. I get the sense that many members of Congress think, as bad as this campaign finance is, that they're better able to raise the money to get themselves reelected than any people contesting for that seat. So maybe they have no incentive to do anything. But what's lacking here, the only thing that can change it is for members of Congress to understand that they have a duty to protect their institution and to understand the system of checks and balances, and that therefore they have to do something about campaign finance.
You talk about in the book, I thought this was interesting, something I think about from time to time, the way constitutional law is taught in law schools. And I was just thinking of the number of lawyers in Congress. So, the way the constitutional law is taught is, through the case system, reading Supreme Court opinions, and this just is, the final word on what the Constitution means, as opposed to, reading cases, but also reading congressional debates, bringing in, say, significant pieces of political thought on different clauses of the Constitution, or thinking about the Constitution as a whole. But that's sort of omitted from the pedagogical record of law schools. I mean, that seems to me this is kind of like a self-feeding process almost.
Yeah, it's not only bad in law schools, but since political scientists have a lot of their students go to law school, they teach it the same bad way also, namely it's all case. And I forget if I even mentioned this in my book. I think I might. But the Supreme Court in 1936 in the Curtis Wright case, was just a case whether Congress could delegate certain powers to the president, and the court upheld the delegation. But then in dicta, namely completely extraneous, Justice Sutherland talked about the president being the sole organ in external affairs, and that sole organ comes from his speech that John Marshall gave in 1800 when he was a member of the House. Of course, the next year he'd be Chief Justice. But Sutherland completely took that sentence out of context, and articles and law reviews and political science journals attacked the court starting in 1938. And finally, 2 years ago, I wrote a brief to the Supreme Court. I said, you made a mistake in 1936, fix it. And last year, the court kind of fixed it, but then added even worse dicta. So can you imagine any other institution, say engineering or medicine, making an error and taking 79 years to fix it? So the court is quite dangerous. They say something, and no matter how much information that what they said was incorrect, they don't have a good system of fixing it.
Yeah, no.
That's quite frightening.
No, that was interesting. Tell us more. This institution you work for. You're a scholar in residence at the Constitution Project. What is that?
Well, it's been around for a couple more than 2 decades. And when I was at Congressional Research in the Law Library, I worked with the Constitution Project, particularly on war powers and state secrets privilege. And it's a nonpartisan group that cares about all the institutions and self-government, and they're very active in many areas. So I had worked with them when I was at Library of Congress and continue to be active with them. And they themselves, they'll regularly contact congressional committees about matters, and they will file briefs in court. And it's bipartisan, nonpartisan experts who care about government.
Okay, excellent. Well, Lou, thank you for your time today and discussing your book with us, Congress Protecting Individual Rights. Thank you so much.
Pleasure being with you. Thank you.
This is your host, Richard Greinch, and you have been listening to a podcast that can be found at libertylawsite.org, where you can subscribe, comment, and find other episodes and links related to today's conversation. Our email address is lal@libertyfund.org.